Hello, and thank you everyone for joining. We'll be starting in just a few seconds. All right. Good morning, good afternoon, depending on where you are joining us from. Thank you for joining our webinar today. My name is Ginny Bromberg, and I am the founder and president of Bromberg and Associates, a language and technology solutions company, as well as the executive director of Linguist Education Online. Today, I am happy to be bringing you our newest initiative called Compliance Corner. Today's webinar will serve as an introductory session to what the Compliance Corner will offer. You will hear from two of our experts, Bruce Adelson and Jessica Yakub, and I will mainly stay off screen and we'll come back for the closing. And right now, it is my great pleasure to introduce both Bruce and Jessica. Hi, Bruce.
Hi, Jenny. Good morning, good afternoon.
Bruce is a highly regarded expert in the areas of language access, disability access, and compliance. With his extensive experience and expertise, he serves as the Americans with Disabilities Act consultant to both the Idaho Supreme Court and the New Mexico Administrative Office of the Courts. Prior to his current role, Bruce was a senior trial attorney for the U.S. Department of Justice, where he worked to ensure compliance with federal laws protecting the rights of individuals with disabilities. In addition to his consulting work, Bruce is also a respected member of the academic community. He currently serves on the faculty of Georgetown University School of Medicine and the University of Pittsburgh School of Law, where he teaches implicit bias in healthcare. Bruce has also taught at a number of other prestigious institutions, including Harvard University, Cornell University, Auburn University, the Johns Hopkins University School of Public Health, and the University of Baltimore School of Law. Welcome back.
Thank you so much. It's always great to be with you all.
Thank you. And now I'd like to introduce Jessica Yakub. Jessica is Bromberg's Director of Operations and Development and our Chief Accessibility Officer. Jessica's role encompasses a diverse array of responsibilities, where she not only supervises and facilitates communication across all departments, but also plays a pivotal role in steering the company towards its development and accessibility goals. Jessica's expertise extends to client relations and language access services. She actively engages with clients to comprehensively assess their language and accessibility needs, offering insightful guidance and solutions. Jessica's linguistic talents enhance her capabilities further, as she is a native Arabic speaker with fluency in French. She holds a bachelor's degree in linguistics with a double major in computer science, earned at Wayne State University. Committed to continuous growth, she earned her MBA at the University of Illinois College of Business, with a focus on digital marketing and universal design. Jessica is an avid accessibility advocate and has earned her CPACC certificate through the International Association of Accessibility Professionals. So today, as I said, I will mainly stay off screen as I'm nursing on bronchitis. So I'm going to welcome again Jessica and Bruce and turn it over to you. I'll see you later. Thank you.
Thank you, Ginny. Feel better.
Thank you.
Thanks, everyone, for joining us today. We really appreciate you taking the time to spend this hour with us on your Friday afternoon or morning, depending on where you're joining us from. Today, as Jenny mentioned, we are going to be talking about our newest community, which is the Compliance Corner. We do want to introduce you to it, but we will also really touch base on a lot of topics of interest to you related to compliance around language access and digital accessibility. We are going to answer questions you have. It is likely that Bruce and I will take some questions you may have throughout the webinar. We will have about 5 minutes at the end to also address Q&A. If we don't get through to all your questions, we will have a post-webinar email going out where we will provide these answers to all the attendees. Additionally, Ala, our marketing specialist, will be in the chat putting some material for you to sign up for our web accessibility audits, to also sign up for the Compliance Corner if that is of interest to you. Before we get started, there's going to be a poll that we would like to put out in this webinar now. This is for us to be able to get insights on the people joining our webinar today. This is in relation to language access and accessibility. So we really appreciate if you take a few minutes to read these questions. There are going to be 3 of them, and answer them, just so we have a better idea on how we're going to steer this conversation today. So the first question is going to be about how are you getting your information about language access and accessibility policy, and that is specifically to digital accessibility. And this is from a perspective of compliance. So where are you getting the compliance information that you need about what you need to do at your organization or your company related to accessibility and language access? We're gonna give it a few more seconds. You should be able to answer that poll. It should be up on your screen. So you should be able to select the option that you want. If you don't see the poll, please let us know right now. We are gonna move on to the next question now. Can you please move on to the next question? This is question 2 about how do you find the information you are currently getting from the sources you're getting it from? How would you rate it on a scale from extremely useful to not useful at all? Make sure that you have your Zoom screen up. Make sure that the window of the poll is selected so you can see the poll when it pops up. It should be on your screen. We're going to give it a few more seconds on this question. And then we'll move on to the third and last question, and then we'll check the results. Hala, can we move to the third question, please? All right, the third question is, what would help you and your organization most in navigating compliance challenges? This is for us to get an idea of what our users and our audience is interested in seeing. We'll give it a few more seconds on this question, and then we're just going to dive right into our conversation today. All right. Thank you, Ala. Let's see what is the results. of our polls today. If we can display that if that's possible. Okay, so for the first question, we're seeing that how are you currently getting information about language access and web accessibility policies? The most people said online resources, websites, and newsletters, and then industry webinars and events, and then internal trainings of a compliance team, and then 7% said other. We would love to know what the other part is. So if you want to share that in the chat, that would be great. And then 1% said external consultants or law firms. Let's see the answers to question number 2. How useful do you find the information you currently receive from your existing resources on language access and accessibility? 49% said somewhat useful. 26% said extremely, 5% said not very useful, and then 2% said not useful at all. So the people in the neutral, not very useful, and not useful at all category, if you want to share your challenges in the chat, we would love to hear about why some of this information is not useful. It could be the resources you're getting it from, or it could be there's like some other challenges with that we can help navigate through maybe in our conversation today even. Ala, can we see question number 3? Okay, what would you and or your organization, what would help you and or your organization most in navigating compliance challenges? Have 36% saying expert guidance and best practices. That's very good because that's what the compliance corner is for. 30% saying regular regulatory updates, also what the compliance corner is for. Practical tips and resources, 31%. Again, all of this is part of the compliance corner, which we'll talk about today. And 3% said something else. Would love to know what you have in mind for the people who had something else. So please put that in the chat if you're open to sharing that with us today. So we do have a quick Q&A that says, is it going to be possible to receive a recording summary of the session afterwards? Please reach out to our marketing team. The recording will be available on demand. They can share it with you. Great. Bruce, let's get started. Let's talk a little bit today about what's going on. Let's give a general overview to the people who have joined us today in this webinar about what is going on in the language access, digital accessibility space today under the current administration. What are we seeing and what should we be aware of? So if we can get started there, I think people are going to appreciate that.
Sure. Well, I think that, excuse me, that can be described, excuse me, in just a few words. A lot has changed. A lot will change. Stay tuned because we're not close to seeing the end of the tunnel when all the changes are in front of us and we can take steps to deal with them. So in short, the administration is changing its approach to the approach of presidential administrations and the federal government to language access broadly. The feds have been very busy, including my former DOJ colleagues, in putting out, I believe, 3 guidance documents in just the last month. Now, these guidance documents say a lot, but they don't say a lot. There's a lot there that provide really intriguing clues about where they're going. There are also a lot of comments that are very controversial as far as, from my perspective, differences between lawyers about what court cases mean. What did the court actually decide? But even aside from that, we should all expect there will be more changes, which is not unusual from administration to administration. One of the differences now is the changes are more wide-ranging and deep so far, and I expect that to continue. So the AG's guidance is important, and all of that, plus many, if not all the things we'll talk about with spoken language access, are tied to the March 1st executive order that declared English as the official language of the United States. Now, I'm happy to give you my opinion of that as we go along, if there are any questions about it. But it all flows from there, with one of the more prominent changes being that at the bottom of documents now, at the bottom of notices from federally subsidized entities, whether it's airports, court systems, hospitals, there has to be a tagline that says, this is part of the English language only executive order implementation. And I'm paraphrasing. So that's a new change. And I'd be curious how many of you have done that or were aware of it. So my office is about 10, 15 miles from DC. So we're living it in this area. We're living the changes. We're living the late night executive order announcements. And I didn't think that at the beginning of the year, I would be spending so much time making my already not perfect eyesight even more strained, looking at various regulatory documents and executive orders. But given the flurry of events, that's part of my responsibility.
Yeah, thank you for the general overview, Bruce. Let's take it back a little to the basics. Let's clarify something about executive orders. I think that people would really appreciate understanding what executive orders do and what branch of the government they're applicable to. So that puts it into perspective. So can we talk a little bit about the executive order for English as the official language of the United States and what that has done so far?
Sure, let me flip the order of answers a little bit. Executive orders are only apply to the federal government, federal employees, and federal agencies. They're not laws, statutes, or broadly enforceable. So it's one thing if Congress passes a law and the president signs it, that's a law. It applies, if not nationwide, it applies very broadly. Executive orders are targeted announcements that signal changes in federal policies and that are mandatory for federal employees and agencies to follow. So the English only executive order is just another executive order. For there to be a implementation somehow of English as the official language of the United States, that would be complicated because there are lots of countervailing legal issues and claims that are involved, and that we're nowhere close to having a bill presented and passed by Congress that says something like that. There are a lot of other things that are going on, including the new federal budget with the federal government, so I don't expect that to happen. But if you read the order, it has clear delineations of what the changes will be. One of the changes is that DOJ will begin investigations of policies and entities that are not federal, that are private business. And it was either in this executive order or an accompanying one where the White House said they will begin investigating how private business, private organizations, nonprofits, how they implement DEI, diversity, equity, and inclusion. Well, they're doing that now. There are several prominent hospitals and medical centers that have been notified of investigation. There have been all kinds of other entities that are being investigated. And in part, DOJ uses, excuse me, the threat of criminal prosecution as an additional persuasive device for the investigations they're doing now. So my understanding is that that's an overwhelming priority and something that takes a lot of DOJ time. And DOJ is already short of attorneys. So how they're managing this is very intriguing to me, given that 2/3 of their attorneys resigned earlier this year. So it's even more of a challenge than it usually is.
Great. Thank you, Bruce, for doing this breakdown. But I do want to pause for a second. There are some interesting questions in the Q&A in the chat. Somebody in the chat, Chris, is asking, do federal executive orders also apply to federally funded programs? Can we address that real quick? Because we get that question a lot.
Sure. When you receive federal funding, you sign something called a certificate of assurance, where you agree that you're going to comply with certain statutes like Title VI of the Civil Rights Act of '64, certain policies and other materials. So they could conceivably apply to federally funded entities. It's like anything, the devil's in the paperwork to see what exactly the certificate they signed says. Can they apply to them retroactively? Well, there are some potential due process issues involved in that, but there could be attempts to apply them to federally funded programs that are not part of the federal government. I have several of them who are clients. No one has told me they've been notified by the federal government that we're now applying these new standards to you. That I have not received because I think part of it is the due process issues. And, on a practical matter, since DOJ is already running short of lawyers in various courtrooms, the last thing they need is a new challenge, which would be a substantial one that they would have to litigate. So that's something that I'm presuming is at work, and that's based on information that I have in my own experience. So short answer to reiterate, yes, they can. If they apply retroactively, that raises a whole other set of legal issues.
Will we see any of that come out after the new budget?
You mean more?
Will we have a better understanding? Will we see any federally funded programs be affected or get their funding cut after the new budget is out?
Oh, sure. There will always be.
Okay.
There are going to be additional funding cuts. DOJ has said they're going to come out with new guidance, and that I expect that to be before the end of the year. Other federal agencies will be acting as well, like the Department of Housing and Urban Development. They've removed translated terms from their website and also pulled down some translation guidance and said they're going to replace it. Well, what they replace it with depends on what DOJ allows. So DOJ goes first, they publish their guidance, and they make sure that the federal agencies are following behind the guidance. So that neither one has occurred yet, but they will within the next several months. That's as much of a guarantee as you can get.
Awesome. I do want to take one more question from the Q&A, which is, given that executive orders only apply to the federal government, can you explain why federally funded entities would be required to include English only or English as official language taglines on the bottom of public documents? And that's from the Spring Institute Advocacy.
Yeah, that's a great question. There are examples of things like I think that's a good example with the new notice requirement that can come up and are not seen as onerous or particularly violative of due process rights because they don't really involve significant changes. So whether or not the executive order through the federal funder can mandate certain changes is almost separate from what executive orders often are used to do, which is to persuade people that this is coming. Now, frankly, there are many online postings and things in the media that still don't talk accurately about executive orders, which is one of the reasons that the Compliance Corner is very exciting to me, because we're not going to do that. We're going to have information that's accurate and dispels any notion that somehow we have to not speak other languages right now because of this English language executive order. That's just not true. So I can't speak to what federal agencies have sent out because of the executive order. But even if nothing has gone out, I think adding one sentence to a document, it just, as I said, won't be seen as an undue burden or onerous in any way. So my bet is having to do that is a combination of all of the things that I mentioned, that people are persuaded to do it, stay on the good side of the administration. It's not expensive to do it. This is something we can manage. So that's my best guess about that.
Yeah, thank you, Bruce. I know there are some other questions in the Q&A. Some of them, this stuff you can find at the Compliance Corner. So if you want the guidance documents, or if you want examples of verbiage required, you're gonna have to come to the Compliance Corner to get this information. And there is a question about that any president can issue an executive order about literally anything, which is true. That doesn't automatically make it enforceable, as it's not a law. And they asked if that's correct. That is correct. So that's a very straightforward answer we're going to give right now. And I think that's what we'll be addressing throughout this webinar today. Bruce, let's switch it up a little bit and talk about AI. AI in the language access space. That's a big topic that people are always coming up to us and saying, is AI illegal under the ADA or under the Affordable Care Act or under this or under the Civil Rights Act, or what can we say related to AI? Can government entities use AI? Are they allowed to? Are they doing it already? Let's talk about that a little bit.
Well, the answer to the, excuse me, your last couple of questions, Jessica, is yeah, of course they are. Federal agencies are using AI right now. A lot of things go on that we don't know about. So to the extent, what extent they're using it would be impossible to know. But I think this is also a very important place to mention that AI is legal. I'll say that again. AI is legal. It's going to be with us until the next new technological innovation comes along to replace it. It's not going anywhere. This administration will regulate AI less strictly than the previous administration. But one point that I made at a conference last week and that I regularly talk about, AI must be coupled with human intervention and human oversight. Because AI, no matter what the creators say, still makes substantial errors or mistakes. And if you're sending something out or using something in a way that expresses bias, let's say, that's on you. It's not just on you, but it's on you, and you better call your insurance company about that. Because if you get sued, the litigation is going to be very expensive. So there's one case as an example that a real estate company set up an AI program to help identify renters in a certain city and in certain neighborhoods. Well, it turned out that they always pick people of the same race, and they always pick people of the same gender, and they always pick the same neighborhoods. Well, especially since I teach bias in medical school and law school, that's a pretty good example and something that I use with my students. Who's responsible? The manufacturer of the AI, the company that's using AI, and if there are any other entities that are somehow involved in communicating or implementing the use of AI. And I will tell you what I tell my medical students, and they don't like this. when you file a lawsuit, you really have to sue everybody. You have to sue everybody because if you miss someone and somehow a claim against them is barred in the future, that's kind of malpractice. You're supposed to know that. So when I sue everybody. I may drop people along the way, but I have to protect my client and then my client's rights. And that means suing everyone so that I don't lose the possibility of a claim. But AI should not be regarded as transient. It should be regarded as something that's here with us to stay, but also as a great opportunity for people with, let's say, linguistic expertise to be like experts on various languages and how languages are communicated, because that's going to become more and more of an issue going forward. And we're just nowhere close to AI somehow replacing human beings. When that day comes, that's a day I hope not to be around to see, because that by itself is going to be pretty scary. But of course, we're not even close to that. So AI is here to stay. Yeah, really. Manage it well. There is a big role for you to play in AI. And my 2 cents is take your shoes off and jump in the pool, because that's our future. And expanding opportunities and expertise is part of what we do as experts and as professionals.
Thank you. Thanks, Bruce. And I did want to bring your attention to something that in the compliance corner, we do a regular, scheduled post about bill tracking and also lawsuit tracking. So we do like lawsuit summaries just for you to be aware what lawsuits are out there, what are the updates on them, what the rulings are on them. Also, we are developing a bill tracking to track any bills on a state level that are related to language access or digital accessibility, just for you to know what's happening on your state and local level, because obviously outside of the federal guidance, there are state and local laws related to language access and web accessibility that you should be aware of. So this is a regular segment of the compliance corner. I did want to say something related to the private sector. So somebody just put in the chat, my Visa card just notified me that all communication, oral and written, will be English only. So let's talk about that. This is a private sector. Let's talk about why they are choosing, why this company is choosing to go, because this is not, they're not impacted by the executive order. They don't have to do this because they are not a federal agency. So let's talk about this climate, this mindset, this shift in mindset, because this company is actively choosing to only communicate in English. They don't have to, and they are not obligated by the law to do so. So Bruce, can you comment on that a little bit? And then we're gonna go to the digital accessibility part.
Sure. Now, it's possible this company has gotten a non-public communications from the Justice Department telling them essentially, don't do this. That happens all the time. It's not necessarily publicized and no press releases. That's what enforcement's all about. But let's assume that's not happening. Then I would imagine that they've done this as part of a public relations exercise. In their view, it's a political response to the administration, meaning we agree and we're going to adhere to the new executive order's language, even though it's not binding on us. So I think it's a combination of several things. Partisanship, it's a combination of collaboration as far as wanting to collaborate with the administration on its priorities and information it puts out, and the possibility that there's some behind the scenes investigation of this particular business. It's the same way with businesses that have dropped their DEI programs. They're not dropping them because DEI is not illegal. DEI is fully legal. It just depends on how you use it, but it is legal. So there have been many large companies like Target, for example, that have dropped DEI programs. They didn't have to. They were influenced to, told to do so, and they did. But there are other companies like Costco that have not dropped their programs. So it's like many other things that we do in life. Evaluate risk. How much risk does this company perceive there is in continuing to have a DEI program? So that's part of the calculation that they go through.
Thanks, Bruce. We do have somebody also, I'd like to comment on this. Somebody said, is it also possible that they are simply trying to cut costs and push the language service cost onto the customers? So when we talk, I always like to bring something up that when we talk about doing language access or doing digital accessibility, we start with the competitive advantage side of things. We don't start with the compliance side of things. We usually try to appeal to the competitive advantage, to the competitive edge that gives the business, rather than do it because the law says so. And usually businesses who have users who don't speak English as a native language or have users with disability, they want to provide these users with communication in a format they can perceive, where it's perceivable. So when you have users in the United States as a credit card company, you are going to have users who don't speak English as a first language, who may not be proficient in English. So excluding these people from your user base because you choose not to communicate to them is not a good business decision, most likely. I think they will come to find that out, whatever credit card company that is, because this is a political move, I would say, for sure. And like Bruce said, we don't know what's happening behind the scenes. It is possible they have received something else to get them to make this move. But at the end of the day, language access and digital accessibility is not a luxury. It's not something we do because we just want to do it. It's a necessity. It's something we have a user base. We have a user base that needs information in different formats, including formats that are in other languages or that are compliant with assistive technology, which is why we have all this effort, which is why there is guidance, which is why the compliance corner exists. So this is just my comment related to that, because we always want to look at it's a business decision as well, and it's a good business decision. You're expanding that market base. You're expanding your reach to your audience when you're communicating in more than English, when you're providing documents, and when you're providing accessible solutions to your users as well. So this is definitely a step back, not a step forward in the right direction.
Jessica,
Okay.
let me throw in something really quickly, that I agree with you that it's a good business decision and very important and is part of the reality of our times. But there are other realities too, and they have made their risk management analysis and decided that they can deal with whatever risk there is. That's a decision they've made. I don't agree with the decision, but there are a lot of things I don't agree with or agree. And what's also important, all the laws that we're talking about on spoken language access do not apply to credit card companies because they're not federally funded. They're not recipients of federal assistance. So all these laws that you hear about regarding spoken language just don't apply to them. So they don't have the same legal imperative as a hospital system would, where they get hundreds of millions of dollars if it's a big system for compliance. Visa doesn't get anything. And so Visa's not required to do what the hospital system is required to do.
Yep. No, and you mean, cutting costs is definitely a big factor. We have to be understanding of that. Businesses are integrating AI for cost cutting solutions as well. So this is something that is very important to recognize as well. Let's switch it up a little bit, Bruce, and let's talk about digital accessibility. Digital accessibility is related to making content accessible to people with disabilities who are trying to navigate the web. I would love to hear from you very briefly the general explanation and understanding and definition under the law of what digital accessibility is.
Well, in the United States, website accessibility has become the thing over the last decade. The number of lawsuits had gone up. COVID brought them down, and I read something last night that the number of lawsuits is climbing again. Because, as you said, Jessica, website accessibility spans a spectrum of issues for people, whether they're limited English proficient or whether they have a mobility disability or a visual disability. And it basically means you create a level playing field as much as reasonably possible between people who are not disabled, let's say, and people who are. So that if I have a disability and you don't, I should be able to get information online that's basically equivalent to the information that you're getting by going online and using my assistive technology to get that information. 10, 15 years ago, there was nothing that came close to requiring this. The DOJ put out new regulations, I think 2 years ago, about web accessibility. First time there's ever been regulations about this. Number of lawsuits is going up, federal lawsuits, and the claims that are being raised are very interesting, as well as the defenses that companies raise. So that's basically my thumbnail of what website accessibility in the US is, at least as a legal matter.
Yep. And let's clarify something related to digital accessibility. There are DOJ guidance on digital accessibility as well. It's also under the ADA. So it's covered in a lot of places. The main standard that is used for digital accessibility is the WCAG standard. The most recent version is the 2.2, but at this point, government agencies are going with the WCAG 2.1. WCAG stands for Web Content Accessibility Guideline. And there is a compliance deadline that the DOJ has issued for digital accessibility that is applicable to state and local agencies. And that deadline is April 2026. It's actually April 24, 2026. And this mandates that you have to be compliant with WCAG 2.1 AA success criteria by that deadline, making sure all your digital content is accessible for people using assistive technology. What person I think will happen is after the deadline, the number of lawsuits on state and local agencies will double, if not triple or quadruple, because there is actually at that point a compliance requirement. So this is something to keep in mind. We don't think there's a lot of awareness on that. And this is applicable to everyone here. Even if you're a private business, you can get sued under these mandates. And this is applicable to you if somebody's not able to access your services because your website is not compatible with their screen reader, they can still go ahead and sue you in court. And we do have a summary of all the lawsuits happening around the country right now in digital accessibility. Digital accessibility, we always like to say, is not a checklist, is not something that you can just go ahead and check off your list. It's something that we need to figure out for every client, for every piece of content, because it is very unique to the audience that you have. It is unique to their needs. It is unique to the disability that they may have. This also includes things related to plain language. So using simplified English or plain language in your content, we do see some effort on state level, state governments trying to put information out in plain language or simplified English to be able to communicate to their constituents better. So from that perspective, There is an enforcement deadline, which we're looking at, and we would like you to be aware of that and make sure you know everything you need to know, everything you need to do before April 2026. Bruce, what do we want to discuss related to digital accessibility?
Well,
Since
I
I've been
think,
asking the question about language access, I think it's time for you to ask the question related to digital accessibility.
I think that's a great point. And there have to be, in the work that you've done, there have to be issues about accessibility for people with disabilities that occur pretty frequently. So, what would be some examples of issues that you see regularly or read about regularly as being commonalities?
Yeah, some of the issues that we look at and we see even listed in lawsuits are very basic stuff. Like you and I were talking before the webinar about just having captions available for videos or captions and transcripts. So just making sure there is captions in your videos and your multimedia content on your website or in your newsletter or in anything where you are discussing a program, service, or activity. That's very simple. There's a lot of tools today that you can automatically generate English captions. You can then edit them and then have accurate and effective captions in your videos, as well as generate automatic transcripts based on these captions. So there's a lot of assistance in that regards. We also see a lot of things that are very, very easy to remediate on a website. Things like having alternative text for your images, making sure that the screen reader does not get stuck in the navigation panel, or that if it does, read the navigation panel, it doesn't read the navigation panel every time you navigate from one page to another. It's very disruptive for contrast. Um, a lot of websites are not compliant with their color contrast. So they'll have a light gray background with maybe some yellow text on it. So there's a lot of examples in the real world of websites where the contrast is not good enough. And even someone without a visual disability may have a hard time reading that content. So if a person who is not low vision or blind can't read the content, it's very unlikely to be accessible content. So some of the issues we see are very basic. There are some more complex issues, obviously, with accessibility related to the content itself, related to, how to work in dynamic JavaScript and make sure that your website is accessible from the back to the front end. But outside of that, starting your accessibility journey and your remediation journey is not an overwhelming task. It is a roadmap that you usually set with your accessibility consultant or the people doing the accessibility work for you. And guess what? If you have a roadmap and you have a plan and you still get sued, and I'll turn it over to you for that, Bruce, because obviously lawsuits, we always wait for the ruling to know what's going to happen. But what we've seen so far is that if you have made reasonable effort to remediate your website, or you have a plan and resources allocated to do your website remediation and your digital content remediation, a judge will take that into account when they're looking at your accessibility lawsuits. So I'll turn it over to you, Bruce, to comment on that very quickly.
Yeah, I agree. I think that's a great point, that courts like to see that entities have some understanding of their legal obligations. So if they come in with a website accessibility plan, which I definitely recommend, the roadmap that you speak about and timeframes to do things, including having done some of the things before the judge gets involved in your case, all very, very important to show that, as you said, you're acting reasonably and you are being diligent about your requirements. There is no requirement here to prove intentional discrimination. It's you're either accessible or you're not. And this was not a part of what is disability discrimination several years ago, but it is now. So if your website, to use Jessica's point, has a dark color with dark color letters that make it virtually impossible to read, If you are sued by someone with a visual disability, it's going to be really hard for you to defend that successfully because all you have to do is a couple of clicks. Oh, yeah, this is your website. I can't even read it. So why should you not lose this case? Because your website is the way it is. So, yeah, I think that you raise some really important points. And every decision I've seen and all the people I've talked to show that you've acted with due diligence and you take your requirements seriously. Plus, that you've already made some changes because I think you would agree that the law doesn't say you have to be accessible tomorrow, that you have to do everything immediately to make sure that you're good to go. Do you think that's accurate?
The law doesn't, as you know, Bruce, the law doesn't say much about how to be compliant or what to do. The WCAG standard is the one that's going to give you the most guidance on what you need to do to be compliant. But the nature of digital accessibility is that it is not something that is just achievable. You just get to a point where you are just fully accessible. So when you see online, you see tools that say we offer 100% ADA compliance. That is not possible. There's no possibility of getting to 100% ADA compliance because accessibility is a continuous effort. Every time you generate a digital piece of content, you have to make it accessible. And depending on what that piece of content is, that approach may be different, and that that process may be different for you. And depending on what the needs of your users are, that process may look different. So that's why we say it's not a checklist. It's not something you can come and say, do this and you'll be good. No, I'm going to tell you start with this and then let's have a process in place to make sure that you're going to be able to maintain this accessibility over the years or over the lifetime of your content. And I do want to talk about someone put a question related to e-learning modules. Are they considered digital assets? Yes, they are. And what resources training are available to provide instructional designers tools and tips to make training modules meet WCAG 2.1 AA standards, particularly for Articulate 360 Storyline. So Articulate 360 Storyline has also accessibility features that your designer should be taking active roles in learning how to use these guidelines as well and how to use these tools. But essentially, and it depends on who your organization is or who your entity is, you may have, if these e-learning modules are public for the public, you will have to make them accessible. If they are for your internal employees and you have employees who have disabilities, you still have to make them accessible, even if they're for your internal employees. So there are things in Articulate that you can use to make content accessible, but it's not enough. The stuff that Articulate, because we use Articulate, so I know exactly what Articulate can offer and what it cannot offer. It's not enough. You still have to do some other remediation manually to be able, like your designers have to be able to go and learn the WCAG, and that's where I would start, is getting them familiar with the WCAG 2.1, because it's very inclusive, it's very comprehensive, and it's gonna have a lot of different guidelines for how to approach different pieces of content. So if it's an e-learning module, if it's a mobile app, if it's a PDF, you would be able to get this information that you need. Another resource that I would really recommend is the World Wide Web Consortium, which is a very wholesome resource for accessibility professionals as well. You can also join the Compliance Corner, where you're going to get things like, one of the most recent pieces that I wrote was about how to make content, non-text content accessible under the WCAG 1.1.1 standard, under the 2.2 WCAG 2.2 AA success criteria. So that's also content that we put out where it helps designers and people learn how to make content accessible as well.
And Jessica, I want to circle back to one of the polls at the beginning of people being interested in regulatory updates. Well, although this isn't about regulatory updates, it's about judicial updates. We have a vast federal judiciary plus state courts. The odds are that the laws of the state of Maryland, where I live, are different than the laws of another state as interpreted by the courts. The courts have different standards and issues depending on where you are. So when you talk about whatever mandate or directives, and there are a lot of them, concerning digital accessibility, one is, well, tell me what your U.S. District Court is doing. What has the Circuit Court of Appeals decided? Because that's the law too. It's just not the law that is as well known. But if you change your website in a way that is contrary to what your local courts have done, federal or state, that's just money wasted. The Supreme Court has not decided definitively on all the contours of this. So we do have, as Jessica said, the WCAG standards. We have DOJ's regulations. But please remember, you got that person sitting in a black robe on a bench. They make laws and decisions that are as binding as anything. Show me that you know what the District Court for the Eastern District of New York decided, because just as an example, there's a big split among New York courts. Depending on where you live in the state, it's going to affect you. So here is another item that you need to know. And as Jessica said, yeah, we can have a lot of information about court decisions, because remember, accessibility lawsuits are on the way up.
And that's how we're going to be able to offer more guidance, because we also wait and see what happens with those lawsuits and see what the judges say and what they decide. And then based on that, we can, have more insights into what is important, what is not, what is happening, where the court system is on digital accessibility. Because as you know, today, there's a lot of mandates, but we, as Bruce mentioned, that there is a backlog. DOJ has less litigators. So we also understand that enforcement may be slow or maybe completely halted to an extent. That being said, we do that we have 3 minutes left. So I really want to just pause for a second and make sure we're not, if you have questions that you would like us to address still, please put your questions in the chat right now so we can answer them. Obviously, the Compliance Corner is up and running. We have content there already. We are planning more content for it, and there's going to be exclusive webinars in the future for Compliance Corner members. I assume that we will have more free webinars in the futures with updates and whatnot, but most of the content will be putting out there related to compliance for language access and digital accessibility is going to go through the Compliance Corner. You get a 14 days free trial, and then you can subscribe. There are 2 different tiers, very affordable. You get exclusive access to our community with free trainings, webinars, and all of the updates that we do on a regular basis, on a weekly basis, as well as our monthly newsletter from the Compliance Corner with the wrap up of everything we did throughout the months. So we hope that you will join us. We have 2 minutes left. If you have any last minute questions, please. And then Bruce, I will maybe leave it with you for closing.
Sure.
I'm also here if you need me.
Oh, yes, Ginny.
go
Yeah,
ahead.
well, Ginny's going to do a closing, but Ginny's going to close the webinar. But Bruce, just I will let you as our legal expert just say the last words.
Thank you, Jessica. And as always, it's a pleasure to get together and talk about these issues. these like AI in a sense, these are all real ongoing considerations. They're not going away. And as Jessica said, the number of websites out there that are non-compliant is just stunningly large. Now's not the time to do that anymore. Plus, there are going to be evolving new requirements and standards coming from my buddies at the Justice Department. You got to know where to go to get accurate information that you can rely on and that you can act on. And that's a big part of why we're doing what we're doing. So, with that, Ginny, let me turn it over to you.
Thank you, Bruce, and thank you, Jessica. And thank you, everyone, for spending part of your Friday afternoon with us. I think this was very informative and very interesting conversation. I'm glad we had it, and I look forward to having more in the future where I can take a more active role and my voice will stay with me for the duration. But in the meantime, I just want to say, um, I want to make sure that we will have a chance to offer the free accessibility audit for your website. If you have a website or if you work for an organization where you think accessibility, digital accessibility might be a challenge, uh, take us up on this offer. We're offering a free accessibility audit, and Jessica will be the one communicating with you about that. Um, if the team can share the QR code right now, we can pause for that. Here we go. And here's the QR code. Please sign up for the accessibility audit. It will be available to you at no charge, whether you are a member of the Compliance Corner or not. It is something we're doing for our Leo and Bromberg community. And of course, I also invite you to join the Compliance Corner by subscribing through the link that was shared in the chat. Lastly, please take a minute after the webinar to answer our post-webinar survey. It's very brief, but your feedback is very important to us for future events and ideas to discuss. You will also be receiving a post-webinar email from the organizers with all the information that we shared and with the slightly longer survey. So thank you so much for joining us today and look forward to continuing this conversation through the Compliance Corner. Thank you. Have a great weekend, everyone.
Thank you. Have a great weekend. Take care.
Thanks, everyone.
You too.
Bye.
Bye.
Bye bye.